For years, the NYPD's DNA collection policy has raised concerns about privacy and over-policing. But now Police Commissioner Dermot Shea says the agency will be deleting thousands of fingerprints and DNA data collected from people, some who may not have even committed any crimes. And right now, officials are at City Hall to talk about these changes. Let's take a listen in.
And sometimes can only get it when a perpetrator is identified by forensic evidence. But there are a lot of things that cops might want to do in order to solve a case that was, as a society, don't let them do it again, like searching a home without a warrant. The state legislature has passed laws allowing police to search homes when they get a warrant signed by a judge. The New York State legislature could have passed such a law for obtaining DNA samples. Many other states have laws that allow for the collection of DNA from people who haven't been convicted of a crime. We haven't. The cops have just decided that this is okay because nobody has not told them not to. I'm here today to say that it's clear that we have to set the rules. Now that we have seen what their idea of reforming their policy is, we know that this can't just be something that we let the NYPD decide for us. Before we get to the new policy announced last week, I want to read from testimony received by the committee from two sources who particularly are worth noting. The first is the Downstate Coalition for Crime Victims, a collective of service providers, victim advocates, survivors, community-based organizations, and elected officials in and around New York City. They wrote, I quote, "We are concerned that the city's current structure of DNA collection and storage is corroding public trust in law enforcement and therefore has a chilling effect in the communities in which we work. The DNA database may serve as a deterrent for survivors and victims to step forward, particularly for those who have either had NYPD collect their genetic material or fear the ramifications of possible DNA collection for themselves or their kin." The second source of testimony that I want to read here is from Howard Baum, formerly the Assistant Lab Director at OCME, and who says that he created the local database in order to speed up processing times, not to create a vast network of surreptitious samples and samples taken from children. He wrote, "Just because I built the technology for OCME to have such a large data bank doesn't mean it should have one. It shouldn't. The City Council now needs to make clear that an unregulated local DNA index cannot continue unabated. Otherwise, the OCME and NYPD will continue to take my idea for faster testing and transform it into a sweeping index of New Yorkers who are now vulnerable to wrongful arrest or convictions. I know that the NYPD has worked hard to reform its policies, but as I've said before, the new policy is half-baked. It doesn't address the main problems with what the NYPD does. It doesn't require a warrant to steal people's DNA without their knowledge. It doesn't even require probable cause. It doesn't limit this practice to only the most serious cases. It doesn't regulate when stolen DNA will be stored in the local database. It doesn't do anything to prevent the NYPD from collecting the DNA of over 300 black men in connection with a single investigation as they did in Howard Beach. It doesn't prevent the OCME from storing that DNA, even though there is no reason to believe that any of those people had done anything wrong. It still leaves the decision as to whether to take someone's DNA and store it indefinitely entirely up to the NYPD. This might be the worst part about all of this. Even if they don't arrest you, even if you don't match the evidence in the case they suspect you of, you will still go into a database. No arrest, no conviction, but the government is keeping your DNA. What possible justification is there for that? There are even bigger problems with the changes the NYPD says it's making. Sorry, I gotta keep going. They made changes to the consent form they give to people. But even with the changes, it still doesn't clearly say what they want the DNA for. It doesn't say your DNA will be compared against every historical and future piece of crime scene evidence until they decide to take you out of the database. It actually seems like the words in this consent form were deliberately chosen to say as little as possible to the person who is consenting. If you really want to provide informed consent, why aren't you saying exactly what you are doing with it? There's more. The new policy still allows the NYPD to steal the DNA of children whose parents refuse to give consent. That's right. I'm talking about children as young as 11, 12, and 13 years old. They are claiming to change the rules about asking a parent when they ask a juvenile for consent to obtain DNA. But ultimately, if the kid already had some water, but the parent refuses consent, the NYPD might still test the water bottle anyway. So what is the value of being able to consent when they're just going to take it anyway? Why don't you just put this in the consent form? You might as well sign this thing because we'll just take your DNA anyway. These changes are not good enough because they don't address the problem of why legally innocent people are in the database. And they do nothing to foster the sense of trust that Commissioner Shea says he's trying to establish. Unless we get some really good answers today, and unless the state does something first, I believe we need to take up legislation to regulate the collection and storage of DNA. And until then, I'm left with only one option as a public official with a microphone, to say to all the members of the public who may find themselves in a police station voluntarily or involuntarily, if you don't want to end up in a government database, don't drink the water and don't smoke the cigarette. I'll now turn it over to Chair Landsman.
Good morning. I'm Councilmember Rory Landsman, Chair of the Committee on the Justice System, and thank you, Chair Richards, for inviting us to join this important hearing on DNA collection and storage. The DNA index system maintained by the FBI is expressly authorized by the DNA Identification Act of 1994, which can be found at Title 34 in the U.S. Code. Regulations governing its operations are laid out in Title 28 of the Code of Federal Regulations. The DNA index system maintained by the state of New York was expressly authorized by the state legislature and the governor, also in 1994, and is codified at Article 49B of the executive law. Regulations governing its operations can be found in Title 9 of New York Code's rules and regulations. New York City's DNA index system, maintained by the Office of the Chief Medical Examiner, however, owes its existence to no such express authorization, either in state law, the city charter, the city administrative code, or city regulations. It just is. The New York State DNA databank regulations enumerate important safeguards concerning notification, access, and review of records, expungement, and familial DNA testing, and it is overseen by a commission of forensic experts, including a specific DNA subcommittee to ensure best practices are adhered to. No external regulations constrain New York City's DNA database. No committee of experts oversees its work. The FBI's DNA index, is limited to persons convicted or charged with crimes, and arrestees if authorized by state law. The New York State DNA databank is limited to persons who have been convicted of a felony or a penal law misdemeanor. Indeed, many of those states that allow arrestees into their DNA database require a separate probable cause hearing before doing so. Some states prohibit entering DNA data from juveniles. New York City's DNA index, however, has no limits whatsoever on who gets put into the database, including kids, mere suspects who are never charged with a crime, completely innocent individuals whose DNA is collected merely to eliminate their DNA from the mix in a given case, and, as we saw in the recent Karina Vetrano murder investigation, hundreds of completely innocent black men caught in a dragnet that to this day hasn't been properly explained. As the New York City Bar Association put it in its written testimony for today's hearing, New York City's unregulated index is less protective than that of any other state, including New York State itself. New York City holds the unfortunate distinction of having the least restricted and most expansive DNA identification index in the country. And how is this most personal of data, our individual genetic code, collected? Rarely with a warrant, frequently without even the facade of consent. Instead, individuals are duped into drinking from a water bottle or smoking a cigarette in a station house, which is then tested, even after someone has invoked their right to counsel. And before you know it, over 30,000 people have their DNA in a government database where technology is stretched to the limit and even ever more tenuous connections are made linking them to criminality. Who is watching? The council must. And we must regulate the city's DNA database, just as our counterparts in the state legislature regulate the state data bank. That's why we're here this morning. It is my hope and expectation that today's hearing will finally result in the council regulating New York City's DNA database. Thank you.
Thank you, Chair Lanceman. All righty, we'll hear now from Chief of Detectives Rodney Harrison, Assistant Deputy Commissioner Oleg Chernovsky, Director Bob Barrows, and Deputy Chief Emmanuel Katranakis. Thank you.
And do you swear to tell the truth, the whole truth, and nothing but the truth, and answer all questions to the committee to the best of your ability?
I do. Good morning, Chair Richards, Chair Lanceman, and members of the council. I am Chief Rodney Harrison, Chief of Detectives of the New York City Police Department. I am joined today by Oleg Chernovsky, Assistant Deputy Commissioner of Legal Matters. To my right is Deputy Chief Emmanuel Katranakis, the Commanding Officer of the NYPD's Forensic Investigation Division, and Bob Barrows, Director of the Legal Operations and Projects. On behalf of the Police Commissioner, Dermot Shea, I want to thank the Council for this opportunity to testify on the city's DNA collection and storage policies. During the transition phase, Commissioner Shea asked me to look at several NYPD databases, such as the DNA database, as well as the gang database, for transparency and efficiency. Every day, the NYPD's dual philosophies of neighborhood policing and precision policing builds trust and solidifies relationships between the police and the communities that we're here to serve. These collaborative efforts between the NYPD and those that live, work, and visit New York City make the city a better and safer place. However, we must never forget that first and foremost, the mission of the NYPD is to fight crime. Neighborhood policing has transformed how we fight crime by partnering with those we serve, allowing us to share information and more effectively solve cases and precisely deploy our resources. We have driven crime to historic lows while simultaneously reducing enforcement to levels not seen amongst big cities. Yet, we all know that a small fraction of our population commit a large portion of the crime within this city. This is why precision policing focuses on finding and arresting the few who weaken the fabric of our neighborhoods through violence and intimidation. As a law enforcement agency, we have a responsibility to use available technology and scientific advancements in a constitutional and legal way in order to protect the communities that we serve. Those victimized by crime unequivocally deserve the employment of every legal resource and investigative tool available. The use of DNA to solve and prosecute crimes is one vital way we advance justice. It is a tool that protects the communities we serve. While it is used to identify suspects, it also has the distinct, crucial, and indisposable ability to exclude and exonerate persons suspected of committing crimes. DNA is a principal means of achieving fair policing, not a barrier to it. The use of DNA technology is one of the most significant scientific developments in our modern era. While the full potential of genetic markers in medicine and science continues to be explored, the utility of DNA identification in the criminal justice system is irrefutable. Law enforcement, the defense bar, and courts have acknowledged DNA testing's unparalleled ability to both exonerate the wrongly accused and identify the guilty. Its use has significantly improved both the criminal justice system and police investigative practices. Much attention has been paid to the process of how the NYPD obtains DNA samples. The NYPD's investigations and tactics are guided by what is required by law, by the courts, and is aligned with best practices in the law enforcement community. DNA samples are collected in criminal investigations by the NYPD, either from crime scene evidence or from suspect individuals having an articulable relationship to an actual crime being investigated. DNA is collected primarily from suspects in two forms, either through informed consent or from abandonment of discarded property. For both of these methods, there is a long-standing jurisprudence stating that there is no reasonable expectation of privacy in an object that is either provided upon informed consent or purposely abandoned. This doctrine has expanded to DNA samples left on abandonment items, even when obtained by indirect means from the police. The driving motivation for the NYPD to collect DNA is to legally identify the correct perpetrator, build the strongest case possible for investigators and our partners in the district attorney's offices, and bring justice to victims and their families. When the DNA is obtained by the NYPD, the evidence is submitted to our Forensic Investigation Division. There, the sample is vetted for DNA testing, and if probative, the collected evidence is submitted to the Office of Chief Medical Examiner's unit. The evidence unit then transfers the sample to the OCME's Forensic Biology Department. If the sample meets OCME's standards for testing, OCME will generate a DNA profile for inclusion in its local DNA index system, known as LDIS. I want to spend the remainder of my remarks today on this very subject, the city's local DNA index system, with specific attention on the city's suspect database and reforms that have been announced by the city. A robust debate has been centered on this database, with some inaccuracies. For example, I want to be clear, the local DNA index system is not an NYPD database. It is not operated nor maintained by the NYPD. The database is maintained by the Office of the Chief Medical Examiner. The immense value of a DNA database lies in its ability to assist in identifying the correct perpetrator of violence. Last year, the database generated over 1,500 matches or hits between suspect DNA profiles and DNA profiles developed from crime scene evidence. Law enforcement agencies have routinely used scientific advancements in their ability to identify those who have committed violence in our communities. The use of DNA is markedly effective. Rather than casting a wide investigative net, it enables law enforcement to narrow its investigation and ensure that charges are brought against the correct wrongdoers. As many criminal justice reformers have noted, one of the leading reasons for false arrests and wrongful convictions stems from inaccurate eyewitness identifications. DNA evidence is objective. It reduces human error that can accompany witness identification procedures, and more importantly, the use of the databases with appropriate safeguards to extract, retain, and remove samples should be embraced. The local DNA index system is composed of several indices, or more commonly, databases such as a missing person index, a crime scene evidence index, and the suspect profile index. In total, the entire system contains over 82,000 DNA profiles. While some have characterized the system as carelessly expanding the number of samples on file, the vast majority of samples are derived from crime scene evidence taken from victims, firearms used in shootings, and other crime scenes. Approximately 32,000 of the profiles, or 38% within the entire system, are suspect profiles. The suspect database is used to compare suspect DNA to crime scene DNA and DNA from one crime to DNA from other crime scenes in order to match or to exclude suspects. The identities of individuals in the local database are not disclosed to law enforcement unless there is a match found between the crime scene evidence and a suspect. Much of the debate surrounding the local database relates to the database containing the DNA of those who may not have been convicted of a crime. State and federal databases contain only DNA from convicted persons. For example, pursuant to the state law, New York's DNA databank only accepts profiles of individuals convicted of a felony or penal law misdemeanor. Nonetheless, 75% of the suspect profiles in the local database also have a corresponding profile with the state's DNA databank, meaning the person associated with the profile in a local database has been convicted of a crime. Many of these convictions are violent felony and sex offender convictions. Additionally, a significant portion of the profile in the local suspect database are associated with individuals who are suspects in multiple, complex, intricate, and ongoing law enforcement investigations. Some have argued against the necessity of the local suspect database since nearly 3/4 of it overlaps with the state DNA databank. However, there is a 21-day lag between the NYPD receives DNA results from OCME and when it receives results from the state DNA databank. Time is of the essence in an investigation. Time makes all the difference to an investigator seeking to identify a violent perpetrator or to a victim of a heinous crime seeking justice and closure. The expediency of the local database allows the NYPD to take dangerous criminals off our streets sooner and to keep our communities safe. Despite false claims or reckless growth, or that NYPD engaged in fishing or dragnet expeditions to collect DNA, the number of profiles developed from arrestees and other suspects remains at about 32,000, compared with 700,000 in the state convicted offender database. When considering since the inception of the local database in 1997, the millions of investigations and arrests by the NYPD that have taken place, the number of profiles would substantially be higher if the department was engaged in broad-based collection practices. Critics of the database also claim that it is teeming with juveniles. Each year, nearly 95% of the DNA samples taken by the NYPD come from adults. The remainder mostly come from juveniles in their late teens accused of very serious crimes. Approximately 5% of the profiles in the local database came from individuals who were juveniles at the time of collection. Our responsibility is to ensure that every profile in the database actually deserves not just initial inclusion, but continued inclusion as well. In this era of precision policing, a database that is oversaturated and provides few matches is of little use to law enforcement and prosecutors. The department acknowledges the public debate surrounding the database and that reforms are necessary to continue to support a criminal justice system that is fair, equitable, and does not compromise our ability to objectively identify perpetrators of violence, help our prosecutors build strong cases, and bring justice to victims. Over the course of this past summer and fall, the NYPD and the OCME engaged in collaborative efforts to review the city's policies regarding DNA collection and storage, and to develop additional avenues to remove suspect profiles from the local database. The results of this collaborative effort includes the creation of a revised NYPD consent to submit DNA sample form, amendments to the patrol guide and the detective guide, the developments of new guidelines for the collection of DNA from juveniles, and the creation of an exit procedure for suspect profiles in the local database without a court order. As a centerpiece of this significant policy change, the department will conduct regular reviews of suspect profiles that have been collected and notify the OCME of approval to remove where warranted. Our first focus will be a comprehensive audit of every suspect profile in the database that is at least 2 years old or older. The entire database will also be reviewed every 4 years for profiles that are at least 4 years old and older. Lastly, going forward, all new profiles that are developed will receive an automatic review upon reaching their second year of existence in the suspect database. This process creates multiple off-ramps and exits from the local database. The presumption is to recommend removal unless the profile is of a person who, at the time of review, has been convicted of a felony or penal law misdemeanor, meaning the person already has a profile in the New York State DNA databank, or continues to be a suspect of a crime in a police investigation or ongoing prosecution, or in limited circumstances was a subject of an arrest or prosecution where no judicial conclusion was reached on the person's innocence. In a continued effort to increase transparency and enhance trust, the department will publicly report data regarding these suspect profile reviews on its public website. In collaboration with the OCME, the NYPD will report the number of DNA profiles in the database, the number removed as a result of the review, as well as a frequency of how often each exception to removal has been employed. In developing an exit process from the database, the department strongly believes this is the optimal route to pursue. The policy exclusively addresses both samples that have been collected by consent or through abandonment. It does not rely on an individual sending correspondence to city agencies or hiring costly legal representation to seek a court order, and it is equitable. Every profile will get multiple reviews, creating fairer results. In addition, reforms to our DNA collection and storage process will also include the creation of a revised NYPD consent to submit DNA sample form. While already in existence, this amended form will clearly explain that consenting and providing a sample result in a DNA profile being developed and stored in the local DNA database. The form states that the subject may refuse to provide consent. In limited circumstances, when a suspect refuses consent, an abandonment sample will still be taken for violent felonies and misdemeanor sexual assaults, which amount to approximately 98% of abandonment samples. Impose strict guidelines for the collection of DNA samples from juveniles. Collection of DNA samples from juveniles will be limited to investigations involving felonies, firearm crimes, sex crimes, and hate crimes. Investigations for other crimes may be included with prior explicit approval from the Chief of Detectives, and this applies to both abandonment and consent samples. Updates to the patrol guide and the detective guide to ensure parent, guardian conferrals and notifications prior to obtaining a juvenile consent sample. Prior to this change in policy, the guidance for taking consent sample from a juvenile was that it was best practice to have a parent guardian present when making such a request. Well, this occurred in most cases. The department believes this should be standard practice, just as it is when conducting an interrogation of a juvenile. It will be required that the parent guardian be notified, that the parent guardian can object, and that the juvenile and parent guardian can confer before providing consent. Streamline the process for removing acquitted individuals. The OCME will accept a certificate of disposition from individuals who have been acquitted in a case for which DNA was taken for the purpose of removal from the local database. This does not require the hiring of counsel, a court order, or a judicial hearing. OCME will consult with the NYPD to ensure the individual is not a suspect in a multiple investigation prior to removal. And demographic transparency. The NYPD will begin to document in ECMS the age, gender, and ethnicity of individuals who are entered and those removed from the database to monitor and review disparities amongst those arrested and those placed in our database. Thank you for the opportunity to speak about this important issue, and we look forward to answering any questions that you may have.
Thank you, Chief Harrison, for your testimony. And I think this is your first hearing as chief?
First hearing in this position.
Yes, congratulations.
Thank you.
Doesn't mean you get a pass today.
No, I don't.
All right.
I know I don't.
So just want to clarify up front what I'm interested in today, and that certainly isn't the local suspect database, not the witness elimination database or the crime scene evidence database. How many people are currently in the suspect portion of the local database?
I think it's Zach.
So Bob Barrows, Director of Legal Operations of the PD. The number is approximately about 32,000 profiles
32,000.
in the entire system.
And the main difference between the local suspect database and the state database is that the local database has people who have not been convicted of crime, correct?
The state database has a criteria of you have to be convicted of a felony or a penal law misdemeanor to be
Pull your mic a little.
I'm sorry.
No problem.
The state's criteria is that in order to be included in the state DNA data bank, that the individual has to be convicted of a felony or a penal law misdemeanor.
So of those people who are in it because you say you got consent, and others are in there because you took their DNA without telling them, how many people of the people in the local suspect database are in there without their consent?
So Manny Katranakis, the Commanding Officer of Forensics. Thanks for that question. It's difficult to say when you look over the years of the data. We see some changes in the trends. We saw years ago that it was about half.
Half were in there without, so half of...
50% were informed consent, and the other half were abandonment samples. And then we saw that trend change where now we see more abandonment samples being collected and less informed consent.
And I just want to go back to something, and so half...
Sorry, Councilman, I would also just add, I think the premise of the question, how many people are in based on consent, I think as the chief has outlined, entry into the database is based off of both informed consent and abandonment samples. So ultimately, it comes down to whether the collection is lawful.
Can you give me a breakdown on that? I want to hear specific
I think
numbers.
Chief Katranakis just mentioned, I think if you look at the trend over the course of 5 years, it's about 50% are taken from consent samples and 50% are taken from abandonment
So
samples.
half of the 32,000, which would be 16,000, if my math is correct.
One other point, council member. I think I just want to make sure that we're clear on what the numbers are. While 32,000 are suspect samples, of that 32,000, there is significant overlap with the state database in terms of who's been actually convicted of a misdemeanor or felony. And based on our estimation, we're looking at 75% of that 32,000 are convicted of misdemeanors or felonies, which means by law, by state law, they are obligated to be in the state database. So this is duplicative of that. So the universe that I think you're really speaking about are approximately 7,000 samples, if I'm doing my math right.
Okay, and out of those 7,000 samples, assuming this is factual information, how many are in there with consent?
Well, I think that's been answered a couple of times. I think when we look at the
So you're gonna
5-year, when we're looking at the 5-year trend, right, we're looking at approximately, it's half and half. But again, that fluctuates because this is the manner in which you collect a sample is really dictated by a particular case. So sometimes it's done through consent, other times it's done through abandonment without consent, but it's the facts of an individual case that's going to dictate the method of collection, what is best in that particular case to solve that case.
So I keep hearing the word trends over 5 years. I'm looking for factual information. So do we have the exact data? If you don't have it, I'd rather you say that.
So we don't have it, and that's something that we're going to look to put in place regarding documentation to ECMS. So when next time there is a review of this database, we'll be able to give you more concise numbers.
And does the OCME, they're present? Okay. Come on down. Yes, you swear.
Hi, I'm Barbara Sampson, Chief Medical Examiner.
And do you swear to tell the truth, the whole truth, and nothing but the truth to the committee and answer all questions to the best of your ability?
I do.
Do you keep information on who consents and who doesn't consent?
No, we do not have that information.
Okay. You can stay there. We're going to get
I
back
will.
to you. So you spoke of cases, and I want to point to Howard Beach. And Mr. Chief, you mentioned in your testimony DNA samples are collected in criminal investigations by the NYPD, either from the crime scene evidence or from suspects. Individuals having an articulable relationship to an actual crime being investigated. Can you speak to what the relationships were between those 300 black men in Howard Beach and the collection of DNA samples? Was there an articulable relationship between those 300 men?
So, and I'm going to ask Chief Katranakis to go a little bit more in detail, but there was investigative information that came in our direction that somewhat led us in the direction of a certain population that caused us to try to get this amount of DNA profiles that amounted to that number. Yeah.
And are those 300, and go ahead, you have more to add.
I'm sorry, sir. You want to?
You were going to say something?
So just to add to Chief Harrison's point, each of the individuals, to answer your question, was developed through the course of the investigation where the NYPD felt that it was necessary to collect their DNA sample. Bearing in mind, without getting into the granular detail of the case, the DNA evidence that was collected and that we were aware of, and the spatial relationship of that evidence based on where we collected it and where it was obtained from, led us to the conclusion that we definitively felt that we had the putative perpetrator's DNA profile. And in order for that case to move forward, that we had to match that foreign male DNA profile that was developed off multiple surfaces and substrates based on the crime scene and based on the evidence that we collected. So there wasn't other evidence that you routinely see. In each investigation, we look at video evidence, we look at fingerprint evidence, we look at a whole host of elements that can be brought to a criminal investigation that weigh into the facts and circumstances and dictate what the appropriate next steps are to advance the investigation. In that particular investigation, I was out there for 2 weeks at that crime scene, day in and day out. I can tell you that the most important and the critical piece of evidence that we needed in order to solve that case and identify the individual responsible for committing that homicide was matching that foreign male DNA profile. So the investigation was driven by coming across suspects as they were developed through the investigation, which just took us in many, many different directions as the investigation developed over a dynamic period of time, as you're aware. And those individuals were brought to the attention of a host of investigators, and their DNA sample was collected.
300 of them, you're saying?
So all of the suspects that DNA was collected from, each of them was exculpated via the database. So all of those that did not match were not arrested and were not brought into a precinct station house. And when one was matched, then we advanced the criminal investigation and moved forward with an arrest.
And out of the 300, how many consented?
Council member, I think we're answering these questions about this particular case broadly for a reason, because the case is still subject to appeal. So we're not going to go into specifics, but I think what both chiefs have made clear is that there were no random stops or dragnets of individuals. There were leads that were phoned in. There were tips that were phoned in. Everybody's whose sample was collected, however it was collected, was done because a lead was provided that drew our attention to that individual. It was not done randomly. We weren't asking for people to stop in the street and collecting their samples. With the process as we rolled out now, which is the review process and auditing process, what will happen moving forward in all cases is that there's going to be a systemic review of samples, and those individuals that are no longer suspects of a crime, that are not mandated to be in the database based on a misdemeanor or felony conviction, will be up for a review to be eliminated or taken or recommended to the OCME on our end to be removed from the database.
And I want to for a second, because obviously this case is what really stoked our interest in this specific area. Are the 299 black men that you took DNA from still in the database?
Council member, again, I mean, I appreciate the strategy of throwing numbers out and having us to agree to certain numbers. But again,
but they weren't convicted.
As I said, the process as created now, this new protocol for reviewing DNA samples will take into account individuals in that case and other cases that were once a suspect based on reliable evidence or tips that were phoned in, that resulted in a collection of a sample, that are no longer suspects in the case, that don't have any convictions. We will recommend their removal from the database.
Right.
Will it take, what I'm getting at is, will it take 2 years for these men's DNA profiles to be removed?
So as part of this policy change that we announced yesterday, last week, excuse me, one of the first things that we're going to be doing is reviewing the entire database of the entire suspect database of every profile that's at least
We're past the suspect portion of this.
Right.
NYPD did their job. You believe you got the right person. You went to people's doors and collected their DNAs, which we can argue is real, whether that's consent in the first place, because that's called pressure in the neighborhood I come from.
Well, I would just.
But what I would say is, why should it take 2 years to have these men's DNA removed from the database? So when we know today that none of them are guilty of this crime.
So if I could just add, what I was trying to get to was that this first level of review we're doing out the gate of every profile that's at least 2 years old or older right now in the database.
But let's forget everybody else. for a minute. In this situation, you went to over 300 men's doors, and we know right now, as we sit here, you built your case that they're innocent. So why should their DNA be in this database for another 2 years? Is there not a process to expedite to get these men out? Did they get an apology? Did they get a letter? Did they get anything? So what I'm getting at, and I don't want to harp on this case for the entire committee hearing, but what I'm getting at is there's a clear pattern here. It shows that there needs to be a lot more oversight. And last I checked, when you round up 300 men for DNA, or whether you're stopping frisking them all in a week, that's called a dragnet. I don't know how to explain it anything differently. If you go into a community or communities and you go into black men's homes and knock on their doors with their babies in their arms and you ask them for DNA, that's a dragnet. So,
I mean, council member, I'm gonna, look, I'm not gonna let you keep repeating that because it's false. It is not a
you did not knock on you didn't go to 300 men.
It's not a dragnet when you have viable leads in a case.
So you had a lead.
And you're following up on the leads called in. You would expect nothing less of us. We sat before your committee at an SVD hearing where you promoted us following every lead to bring justice to victims. The victim expects nothing less. You expected nothing less at other hearings. You expect us to follow every lead. You don't want us to shut our eyes and ignore leads coming in an unsolved, horrific crime. Mind you, happened in the borough of Queens, but this happened in an area that did not have video evidence. It was unsolved for a period of time, and we needed to follow every lead coming in. Now, to your point about removal protocols, we heard you. We heard the criticism. We worked with the council. We worked with OCME, and we developed protocols not only in one particular case, but across the board for individuals that are similarly situated to come out of the database without requiring a court order. That's what we did here.
What is the makeup of the local suspect database?
Mr. Chair, if I could just go back for 1 second.
No, I don't want to go back for a second. I want to hear so I heard what you said. What is the racial breakdown of the people in the database?
So, unfortunately, we don't have that information, and that's
Does the NYPD collect race and age information for the people they arrest?
We do.
Say it again?
We do.
You do. And you don't have information of who's in this database?
No.
Does the NYPD submit all of the suspects to the local database as well?
I'm sorry, repeat the question?
NYPD collects race and age information for the people it arrests, correct?
Yes.
And does the NYPD also submit all of the suspects to the local database?
All of the local suspects to the database?
All of the suspects.
Suspects of.
So in a case of
so
the case in
93
Howard Beach, would you have submitted all of those individuals into the local database?
No, suspects are submitted based on if we believe DNA is relevant in a particular case or for a particular suspect, it's submitted. It's not submitted for every arrest that's made. I mean, I think one of the numbers that seems to be overlooked routinely when we talk about DNA evidence is that there are 32 suspect samples, 75% of which are supposed to be in the state database by law because they're convicted of a misdemeanor or felony. The database has been around since 1997. During that period, there have been millions of arrests. What we're talking about is a fraction of individuals. That shows that we're being selective, diligent, and careful about in what cases are we collecting DNA evidence. I mean, those numbers bear that out.
OCMA, do you collect demographical information? You do not.
Mr. Chair, if you just mind, in my opening remarks, I identified this concern. Now that I'm in this new position and Commissioner Shea asked me to take a look at it, working with the executives that oversee our ECMS process, that's going to be rectified. We're going to make sure that, once again, as the demographics of people that we're taking samples from is submitted. So once again, we need to get it out to the public, we're able to distribute that information a lot more cohesive in the future.
So you mean to tell me the NYPD collects no demographical information here? So in the gang database, you got demographical information. I'm sure well, I can't even say the facial recognition, but all these databases, this is the only one you have no demographical information on.
We don't have it now, but we will have it, and we're putting something in place in the very, very near future.
Let me just go back to the OCME for a quick second, and I'm going to hand it over to Chair Landsman. So the OCME is supposed to be an independent agency from the NYPD, correct?
It is an independent agency from NYPD.
Why is your policy to maintain a database of whoever the NYPD says you should, unless a judge tells you otherwise?
The role of the OCME is to maintain the scientific integrity of the database, and we do that to the utmost. We are adherent to all of our oversight's requirements. Now, that includes the CODIS, the FBI requirements, and we use those regulatory measures over the local database as they apply, as well as state and federal guidelines as well, national guidelines. All our policies are we provided to you before this hearing at your request, and they are also available on our website.
Can you comment on the testimony of Howard Baum, who says that this was never what the local database was supposed to be and has been expanded beyond what it should be?
Howard Baum was a scientist who left the agency in the middle 2000s. He was one of the team of scientists that built the local database. He is, of course, entitled to his opinion as an American, but I sit here today as the voice of OCME, and I want to just reiterate that the importance of the scientific integrity of the database, that is our role. We are independent, as you pointed out, from law enforcement. So decisions that are influenced by law enforcement needs need to be made with law enforcement and with balancing civil liberties. And that is why I'm so happy to have this opportunity today to have this conversation.
So you agree civil liberties are important here?
I do.
Okay. Chief Sampson,
and the police department agrees that civil liberties are important.
You're a little behind the 8 ball on this one.
I'm not sure about
that. Chief Sampson, what is your understanding of what OCME analysts think about their role in the storage of surreptitious samples and samples of children who haven't been convicted?
I'm not aware of the details of the opinions of all my staff on this topic. Like I said, we are responsible for the scientific integrity of the database, and that I do firmly believe we maintain to the highest degree of scientific standards.
But I want to just point to my understanding is that analysts have raised their concerns to management about these practices and that issues around the local suspect database are impacting morale in the agency. Is that true?
I have often conversations with scientists addressing many of their concerns, and I take them all very seriously. And like I said, we need to balance the needs of law enforcement and civil liberties in this arena. And I'm glad to be able to do that on behalf of OCME today, reminding you that we are the scientific entity here, and we must remain independent from all outside influences. So our concern is maintaining the science behind this database to the highest degree.
And I understand science, but unfortunately, black men are being experimented on in this city and in our communities. And you bear some responsibility here as well. No one is getting a free pass. So I would really implore you to look at this more than scientifically, because there are communities we're trying to build trust with who will never build that trust because of the Wild Wild West. I also have learned that the DNA criminalists have been even campaigned for state law changes to match the rules of the state database, pushing OCME management to change the policy of processing surreptitious samples. Can you comment on that?
I am not aware of any effort by our employees to look to the state to regulate this.
Last question I have for you. I've also been told that there have been high-level discussions with the first deputy mayor's office about changing these policies about DNA storage. Is that true?
Oh, NYPD and OCME have been in conversations about the proposals that we talked about today, so yes.
Okay. I'm going to turn it over to Chair Lanceman. Thank you.
Thank you. So, numerous courts have had to consider the status of OCME's database, and they've concluded that the database is subject to state law. As recently as last year, an important court in New York, the Appellate Division, First Department, in the Fabrizio case, which I'm sure you're familiar with, expressly held that the New York City database is subject to the state law, which established the database, as I said in my opening statement, in 1994, which established a state database. So I want to ask a series of questions related to the city's database and its compliance and consistency with state law and regulation. So, for example, Executive Law 995-7 limits inclusion in the state data bank to felonies and penal law misdemeanors. Are there any regulations, in your view, that similarly limit which underlying offenses can go into OCME's DNA database?
We're not aware of a regulation, but I can...
Sorry, sir.
I'm not aware of a regulation, but I can tell you that felonies and misdemeanors would be the only instances that we would collect DNA from a person. And misdemeanors, being the small number that they are, would be sex offenses.
Right, but
So to answer your question, it's
you're
consistent with state law in a sense where it would be a crime, a felony or a misdemeanor.
But you're putting people into the database, whereas the state database is limited to people who've been convicted of felonies or misdemeanors. You're not bound by that same constraint in your view, because if I'm not mistaken, the OCME database, the New York City database, has people who have been arrested for, suspected of, charged with, but not necessarily convicted, which is a limitation that the state imposes on the state data bank. Is that correct?
I think as Commissioner Chernovsky pointed out, 75% of those individuals are convicted offenders, convicted of a penal law misdemeanor.
Right, so
or felony.
Not to belabor the point, because this is a very straightforward question. 100% of the state database are people who've been convicted of either a felony or a penal law misdemeanor, whereas within the city database, there are a percentage of people, maybe it's 25%, maybe it's some other number, who have not been convicted, who are merely have been suspects or have some other circumstance, have been arrested or were investigated, but have not been convicted. And in that sense, the city database is less restrictive and is inconsistent with in terms of requirements for who goes into the database than the state database. That's a really straightforward question.
Was that a question or a statement?
Well, I'll rephrase it just so there's an inflection at the end and there's no misunderstanding. Does the city database include people who have not been convicted of felonies or penal law misdemeanors?
So, Council Member, I think your question is about the different standards, right, of the database. And this is not an issue that has flown under the radar. This is not an issue that has flown under the radar since 1997. There are court decisions that acknowledge.
I don't mind you giving an explanation. I want this to be a free-flowing conversation. But your response really needs to start with either yes or no.
So, yes, we maintain profiles of not only convicted offenders, of people that are suspects in cases. Yes, that is.
Okay. So the same section of the executive law effectively excludes juveniles and youthful offenders from the state database. But if I'm not mistaken, you've testified to this, I believe, OCME's DNA database does include juveniles, youthful offenders, and children, correct?
So I think this is a more dynamic.
Again, we
back
gotta
and
have
forth. It's not a yes or no question. So
Well,
I
let me
want to put out.
rephrase it. Does the city database include DNA profiles from juveniles?
It does include profiles from juveniles, yes.
Okay.
And we think that's lawful.
Well, I understand you may think it's lawful. I just want to establish what you have and what you don't have. Okay?
Well, I think the chief's testimony pretty in-depthly outlines where we collect and who we're collecting from. What I want to say is, like, this is not a new issue when it comes to that we have a state database with one set of criteria and a local database with others. First, there are a number of cases, there are a number of courts that have held that the local database does maintain different profiles, that it's not subject to the executive law. I think the decision that you're talking about, the recent one in the Sammy F. case in 2019, focused on a narrow issue of whether the Supreme Court could expunge a youthful offender adjudication, a profile related to a youthful adjudication.
But in order for the court to, in order for the court to reach that conclusion,
Right.
the court, not me, I wasn't sitting on the court, I didn't write the opinion. In order for the court to reach that conclusion, they did not have to first conclude that the city database is subject to the state law.
I think with respect to the issue being youthful offender convictions and whether the Supreme Court can expunge a profile in the local database, I don't think it's just that the local database has to match everything with the state database. That issue has been decided in numerous
You're
courts.
entitled to that opinion.
But it's not an opinion. There's a number of cases that have held that the local database
But you know what?
can maintain profiles aside from what is required under the
This isn't even
executive
about
law.
that. This isn't even about, that's not even where I'm going. So don't worry.
And we have been watching a press conference streaming live out of City Hall. That's where officials are speaking about the NYPD's plan to delete thousands of DNA records from people who have never committed a crime. Last year, explosive reporting revealed that the agency was storing more than 30,000 DNA and fingerprint records in a database. And today, some city council members slammed the NYPD for allegedly using shady practices to get DNA from people and said the commissioner's new plan to delete some of the records is not enough. But the NYPD defended the practice, saying that DNA collection is essential to keeping New York City safe, and that last year, police matched 1,500 people to crimes using this database. And we'll have many more details coming up on this story later today. But first, we are going to take a quick break. We'll be right back right here on CBSN New York.